All right, welcome everybody to the gun control debate. I introduce Judge Johnston, who's a judge of the 13th Judicial Circuit of Alabama. A lifelong resident of Mobile, Judge Johnston received a BA in history from the University of Alabama, as well as a JD from the University of Alabama School of Law, where he helped found the UA chapter of the Federalist Society. He had a notable career in private practice and was appointed by Governor Bob James as circuit judge in 1997, becoming the first Republican to ever hold a circuit or district judgeship in Mobile County. Judge Johnston was elected without opposition in 1998, 2000, and 2006. In addition to
Better add 12 too.
In addition to a lifelong study of law and politics, Johnston is an avid amateur astronomer and is a member of the Association of Lunar and Planetary Observers and the Astronomical Society of the Pacific. Johnston is an active shooter and is dedicated to preserving the shooting and firearms heritage of the United States. He is a member of the National Rifle Association and Second Amendment Foundation. He is an active member at St. Paul's Episcopal Church. He is also a NRA certified firearm instructor at Gunport in Coden, Alabama.
Plugs Code in. Yeah. Thank you. Yeah.
I want to
Go ahead.
Professor.
Yeah, that's right.
Really quickly.
And we can speak it.
Okay.
We flipped a coin and I won. So.
I wanted to introduce y'all to ACS's speaker for this event. We have Professor Kinkopf of Georgia State University's School of Law, and he graduated from Boston College for his undergrad and then went on to Case Western Reserve University to complete his JD. He has served as a law clerk for the U.S. Court of Appeals for the Sixth Circuit. He has been honored as a senior fellow in public law at the Duke University School of Law. And he actually came and spoke last year about drones. I don't know if some of y'all were able to attend that event. And we're very pleased to have him return and speak on this issue. And with that, I will give it away.
I was wondering, is that drones that fly or drones that walk around? Because we all see the ones that walk around, I'm afraid. Too much. Y'all keep eating, don't worry about the smacking and all. That's kind of like a courtroom in Mobile, Alabama, I'm afraid. My friend and former client, retired Chief Justice Perry Hooper, referred to me and Mr. Agricola here as his Patrick Henry lawyers, and that kind of set me off on a study of Patrick Henry. Well, one of Patrick Henry's issues, one present issue that Patrick Henry addressed that we're addressing today is, he made the statement, guard with jealousy attention to the public liberty. Suspect everyone who approaches that jewel. Unfortunately, nothing will preserve it but downright force. Whenever you give up that force, you're inevitably ruined. Now, in spite of the slide towards the police state by the current and the past administrations, we still have for a time are able to gather for a debate. And for that, I thank the Constitution, I thank the Lord, and I thank Samuel Colt for that. Now, friends, guests, and my distinguished friend from Atlanta, thank you for having us here today. And let me say here, you have a beautiful school. I actually knew Jimmy Faulkner fairly well and ate fried chicken dinner at his house many times, and he gave me 2 words of advice. He said, perseverance is the most important quality that a person can have. And the second word of advice is don't ever let anyone name a private college or university after you, because you'll spend the rest of your life raising money for that school. And I think that happened here. As a proud owner of a Colt AR-15 since 1985, who's never shot anyone, by the way, I thank you for inviting me. Now back to the Colt AR-15. Why would anyone ever need a Colt AR-15 or a Bushmaster AR-15 or whatever? Well, first, we have a Bill of Rights, not a Bill of Needs. And second, living in Mobile, Alabama, a coastal city, I'll tell you a personal story. Hurricane Katrina hit in 2005, and one of our judges was quite ill and had to go into the hospital with cancer and had to abandon his waterfront home and left me responsible for it. Well, I wasn't about to stay there because it was an evacuation zone. The next morning, myself and the court police chief made it to the home at 7 a.m. I had the Colt AR-15, and my police chief had my Beretta Wright shotgun, by the way. But we reached the rubble of the house by 7 o'clock or so. The restaurant down the street had already been looted of all the liquor, and the residents were already drinking the liquor and running around like they were insane. But let me tell you, those 2 guns settled down everything. Everybody left, and there was no violence, and everybody left us alone. And I was amazed at that early in the morning after, really stunningly bad hurricane. This house of his looked like a tsunami had washed it 100 feet inland. You couldn't even get in it to rescue anything. And after he told me what was in his safe, I kind of wanted to rescue it, but couldn't do that. You all are sitting in one of the most dangerous places in the state of Alabama right now. It's called a gun-free zone. And why is that one of the most dangerous places in the United States? Because that's where every major mass shooting, except one, has taken place. And why is that? Well, bullies pick on the old, the weak, the drunk. They pick on helpless people. Mass shooters pick on folks who can't fight back. Law-abiding citizens like ourselves, we obey the rules. Criminals, by nature and by definition, don't obey the rules. You all know, unfortunately, about the Aurora theater shooting out in Colorado. The facts are all over. They're mostly wrong. He had 6,000 rounds of ammunition, which I weighed on my scale, which would have approached 150 pounds. So he didn't have 6,000 pounds of 6,000 rounds of ammunition on him, or he would have been carrying 150 something pounds of ammunition in addition to everything else. But in spite of that, he passed 7 movie theaters that were closer to his house that were not gun-free zones in order to get to the movie theater that he attacked. Now, does that prove it? Not necessarily, but it's just kind of an odd coincidence. Some of the movie theaters actually were larger than the one he attacked. Now, what about Western Europe, the idyllic place where gun control has worked? Until Sandy Hook, 2 of the worst school shooting massacres had taken place in Germany, of all places, where it takes you over a year to get a bolt-action rifle. Germany. And if you ever want to Google a list of mass shootings in Western Europe, you remember the one that took place in Norway recently. Atrocious, where they have extreme gun control. Now, some gun grabbers would rather ban all firearms and set up a police state, such as the one that our current president and our predecessor president seem to be bent on installing. If it would save even one child's life, the argument goes, we need to do this. This argument, of course, is so extreme because more children are killed first in traffic accidents. Secondly, they're killed in swimming pool accidents and jacuzzis. And third, they're killed in firearms accidents. Now, I don't recall an inalienable right to have a jacuzzi or a swimming pool, and yet we have so many people so quick to want to ban guns, to limit guns, and there's generally an ulterior motive. Many of you know Judge Kaczynski on the Court of Appeals, and he's famous for a lot of things, interesting character, but he issued a dissenting opinion in Sylvia versus Lockyer that I really want you to read. He was a Holocaust survivor coming to this country at 10 years of age from Romania. His dissenting opinion said, all too many of the great tragedies of history, Stalin's atrocities, the killing fields of Cambodia, the Holocaust, to name but a few, were perpetrated by armed troops against unarmed populations. Many could well have been avoided or mitigated had the perpetrators known their intended victims were equipped with a rifle and 20 bullets apiece, as the Militia Act required. If a few hundred Jewish fighters in the Warsaw Ghetto could hold off the Wehrmacht for weeks, then 6 million Jews armed with rifles could easily have held off the German army and not been herded into cattle cars. My excellent colleagues have forgotten these bitter lessons of history. The prospects of tyranny may not grab the headlines the way vivid stories of gun crimes routinely do today. But few saw the Third Reich coming until it was too late. The Second Amendment is a doomsday provision, one designed for those exceptionally rare circumstances where other rights have failed, where the government refuses to stand for election, where the courts can or won't enforce their decrees, and where no one can be found to oppose. However improbable these contingencies may seem today, facing them unprepared is a mistake a free people get to make only once. Fortunately, the framers were wise enough to entrench in our constitutional structure the right to keep and bear arms. The purpose and importance of that right was still fresh in their minds, and they spelled it out as clearly as they could so it would not be forgotten. Now that is very powerful, especially from somebody whose family had to flee the Third Reich, and that's something that nobody wishes upon anyone else. Our rights have been referred to as inalienable, and in my opinion that meant they existed before the Constitution existed. And you can make a strong argument that the right to keep and bear arms is the oldest of the right. Freedom of the press, how long has that existed? Well, practically, because when Gutenberg's press was invented, you can trace the right to keep and bear arms back to the Code of Justinian, if you want to, very easily, back to the Saxon days in England. Remember, under Lockean natural law, we're born with natural rights, and one of the natural rights is the natural right of self-defense, and we cede as few of these rights as possible to the government. Now, our forefathers who expelled the British, and you know, we use the term Revolutionary War, it's really incorrect. It ought to be a war of independence, but nevertheless, that's the name. They viewed the fact that they had that right to keep and bear arms, and they never ceded it to the government. And you can read in the state conventions that took place at the time of the ratification of the various of the constitutions in the various states. No, perhaps the current president will treat the Second Amendment with as little respect as the rest of the Constitution, but I don't think the people will let him. No matter how many armored personnel carriers, no matter how many hollowed point bullets the Homeland Security purchases, nor how many drones are put in the air to surveil or possibly kill. To the contrary, they were frightened, our forefathers were frightened about the unchecked power of government could do with a standing army. In the words of Noah Webster, who was more than a dictionary writer, who argued that a state militia could always oppose a standing army. Listen to what he said. Before a standing army can rule, the people must be disarmed. As they are in almost every kingdom in Europe, the supreme power in America cannot enforce unjust laws by the sword because the whole body of the people are armed and constitute a force superior to any band of regular troops that can, on any pretense, be mustered in the United States. A military force at the command of Congress can execute no laws but such as the people perceive to be just and constitutional. Do y'all believe that today? I mean, aren't there some pretty unjust laws that are being executed? James Madison, a standing military force with an overgrown executive, will not be long safe companions to liberty. The means of defense against a foreign danger have always been the instruments of tyranny at home. Among the Romans, it was the standing maximum to excite war whenever a revolt was apprehended. Throughout all Europe, the armies kept up the pretense of defending and have enslaved the people. But it's terrible public policy to make horrible abuses that took place, like at Sandy Hook and Aurora, to make public policy based on those. That's why we can burn a flag, that's why we can read semi-seditious literature, and perhaps look at a girly magazine. The right to keep and bear arms, as I said, I think is one of the most ancient rights. Code of Justinian, in fact, is interesting. It stated, we grant to all persons an unrestricted right to defend themselves so that it is a proper subject. Anyone, whether a private person or a soldier, who trespasses upon fields at night in search of plunder or lays by busy roads plotting to assault passers-by, the immediate punishment in accordance granted with it. Let him suffer the death which he threatened and incurred what he intended. Think about freedom of religion. That is an inalienable right, but has it really ever been recognized as such? Go to the Massachusetts Bay Colony back in the 1600s and try to practice some off-brand religion and see what would have happened to you. look at the experience of the Mormons as they were driven basically into the desert. American jurists have always considered Blackstone, of course, as kind of a demigod. Blackstone stated, "The fifth and last auxiliary right of the subjects, which I shall presently mention, is having arms for defense, subject to his condition and degree, which are allowed by law, which is also declared by the same statute, and is indeed a public allowance under due restrictions of the natural right of resistance and self-preservation, when the sanctions of society and laws are found insufficient to restrain the violence of oppression." I was concerned when I first read that a few years ago, especially the portion allowed by law. That was not a restriction on what you could have, it was a requirement. A poor man could only have, let's say, a pole spear. A rich man had to have a sword, he had to have bows, he had to have more armaments. So that didn't restrict the right to keep and bear arms, it required various arms to be had. Finally, Joseph Story, who, of course, was in addition to being a member of our Supreme Court, but he also wrote the commentaries, which is kind of a neat thing to have going on there. The right of the citizen to keep and bear arms has justly been considered as the palladium of the liberties of the Republic. And by the way, Pallas was the statue that guarded Troy, so palladium is the symbol of the bulwark of tyranny. Has been considered as the palladium of the liberties of the Republic, since it offers a strong moral check against the usurpation and arbitrary power of rulers, and will generally, even if these are successful in the first instance, enable the people to resist and triumph over them. And least anyone think let's see now, we'll get to that. If you sat in my seat at the 13th Judicial Circuit for a day, you would see that while we do live in a peaceful society, we don't have to worry about marauding bands of Mongols overrunning the country. You see it on a smaller scale. And I see every day, while I don't consider that the main reason for the Second Amendment, you see the self-defense being used every day. 4,000 times a day, firearms are used in self-defense situations. Most of the time, they're never even fired. They're brandished and the criminal runs away. Many of those aren't even reported. So with that, I don't know how long I've been since I have no watch, but I think we have, what is it, a 2-minute question from the professor or from y'all? Or
I think he's going to go next.
Go next, all right.
How many minutes?
About
15 minutes.
Yeah.
Okay.
Thank you for inviting me. It's a pleasure to be here again. I didn't realize until I arrived here that this was going to be a debate, so I prepared a really boring talk about just describing the state of the law on guns.
You don't think mine wasn't boring?
No, yours was great. But now that I found out it's a debate, from what I understand, I'm here to defend tyranny. I think that's a losing proposition, so I'm going to try to go off the board and do something different. And just talk a little bit about the Constitution and the Constitution as it relates to the Second Amendment in a very general way, and then we'll leave it to Q&A for some of the specifics. Let's see, the judge read a lengthy quote from Judge Alex Kaczynski. I have a quote from another darling of the Federalist Society, and that's Judge J. Harvey Wilkinson on the Fourth Circuit, who in one of the post-Heller cases wrote the following: "To the degree that we push the right beyond what the Supreme Court in Heller declared to be its origin, we circumscribe the scope of popular governance, move the action into court, and encourage litigation in contexts we cannot foresee. This is serious business. We do not wish to be even minutely responsible for some unspeakably tragic act of mayhem, because in the peace of our judicial chambers, we miscalculated as to the Second Amendment rights." Judge Wilkinson was trying to, and I think in the best of constitutional traditions, leave open to the public the right to determine for themselves what to do about guns and gun violence. And the Second Amendment, I think, just in very general terms, is not an impediment to that. Right now, last week there was a lot of public attention on the Supreme Court as it considered the question of same-sex marriage in two separate cases. And in the first of those cases, the case from California on Proposition 8, Judge Alito observed, and this got a lot of press, Judge Alito observed that same-sex marriage is newer than cell phones or the internet. Well, I know something that's newer than cell phones, the internet, or same-sex marriage. And that's the individual right to keep and bear arms. Right? That was announced in 2008 in the Supreme Court's decision in Heller versus District of Columbia. Prior to that, no Supreme Court case had ever recognized an individual right to bear arms. Prior to Heller, the common understanding in Supreme Court opinions was that the Second Amendment protected a right to keep and bear arms in connection with service in the militia. And there weren't a lot of cases, there wasn't a lot of definition about what was meant by militia, right? But the cases the Supreme Court decided had uniformly come to that conclusion. Now, post-Heller, we have this whole new world. The Supreme Court in Heller determined that the Second Amendment does indeed protect an individual right to keep and bear arms in your home for the purpose of self-defense. Right? That leaves open vast terrain. What about the possession of arms outside the home? What about the possession of arms for purposes other than self-defense in the home? The Supreme Court didn't tell us. The Supreme Court, in fact, in Heller, emphatically didn't tell us what that meant. So it didn't tell us what the Second Amendment means with respect to possessing arms in order to repel federal government tyranny, right? It has left a lot open. There are a lot of hints in the case that the court means to be pragmatic going forward, in keeping with what Judge Wilkinson said after Heller, that it's to be left to popular governance, right? I think the example of the standing army is a good one for thinking about these kinds of questions, right? It was a matter of great controversy at the time of the framing, whether or not we should have at the federal level a standing army. Many people were concerned that a standing army would be a source of tyranny, right? That the federal government would use a standing army as a police force, would use a standing army as a force to bring the public to heel. Right? But that wasn't the only concern the framers had. The framers' concern wasn't strictly liberty. The framers, of course, were concerned with liberty, right? But the framers also were taken with our experience under the Articles of Confederation. Right? The Articles of Confederation set up a national government that couldn't oppress its way out of a paper bag. It was so weak and so impotent, it could never oppress anybody. Now, put that way, that's good, right? Who wants a government that can oppress people? The problem was the government also couldn't protect people. It was completely impotent. And so the framers were concerned that we had a threat to our security from other countries. And the United States, our nation, could not defend itself against foreign invasion. Our country was left subject to internal strife, right, because there wasn't a national government to superintend things. And so when the framers went to Philadelphia, they went with, in their minds, not only the need to preserve liberty against the potential for oppression by a central government, but also impressed very much with the need for an effective self-government that could help the people preserve life, liberty, and the pursuit of happiness, right? And so the Constitution sets up a government that is largely agnostic as to these kinds of fundamental questions. It leaves it to us to determine whether or not we will have a standing army. And if we have a standing army, on what terms? So it was quickly determined that we could have a standing army if we provided a variety of safeguards, right? And you can find in statutes all kinds of safeguards, ancient safeguards going back to the period of the Constitution's founding, that are meant to preserve us against the potential use of the military for oppressive purposes, right? One is the Posse Comitatus Act. Another is the long-standing statutory prohibition on appointing a Secretary of War, now a Secretary of Defense, from the military, right? The person has to have been a civilian. Okay? There have been a few periods in time where that requirement has by statute been waived, but for the most part we require civilian control of the military to prevent it from becoming its own force, its own tool of oppression. Okay? Similarly with guns. Can guns be a source of protecting our liberty or protecting ourselves, defending ourselves against various kinds of threats? Sure. Can guns be a threat of violence in ways that are problematic? Yes. So what do we do about that? Well, we get together, we have a debate, we look at the facts and the data, and we determine how to govern ourselves. That's democracy. That's the project that the Constitution sets out for us. And guns are really no different than anything else, heated rhetoric aside. I don't think I've gotten a warning about time, but I'm going to stop there and turn it over to questions.
Who will be the first?
Well, I have one.
Go.
What would be the constitutional issues raised by a statute passed by Congress that banned possession of firearms?
Firearms itself. And what they have generally said is unusual type of firearms. But let's back up a little bit. I think the idea was you were allowed to have the same type of firearms that a common infantry soldier had. 1776, it was a musket. Today it's an AR-15. But what they generally said is unusual type of firearm can be banned. Flamethrowers, you know, the missiles, all the things that you hear about. And that leaves a wide discretion. But I think all firearms, I think Heller, McDonald, that's just off the table. And I think the magazine issue is off the table too, because 20-round magazines, 18-round magazines, those are in such common use by police departments. It's going to be kind of hard to say those are unusual. I don't even know where I got up, other than I have 2 cracked ribs, and then it feels better.
Okay. Well, you're asking me to give the boring talk that I set aside, but you asked for it. So after Heller, we know that the federal government cannot, and state governments, cannot prohibit you from possessing a weapon in your home for self-defense. Right, and in Heller, the court says that's handguns because they're commonly used for that purpose. What beyond that is within the scope of the Second Amendment, we don't know. Now, the court set out 4 categories of traditional regulations of firearms that they say are presumptively valid. One was, as you referred to, unusual and dangerous weapons, like flamethrowers, grenade launchers, surface-to-air missiles, right? Those would be unusual and dangerous weapons. Those can presumptively be prohibited. Although the court doesn't tell us if that's because those are outside the scope of Second Amendment protection, or if they're within the scope of Second Amendment protection, but they would pass whatever level of scrutiny it is that we're supposed to apply. The court didn't tell us that in Heller. But presumably those kinds of limits would be permissible. Would that apply to magazine capacity? You know, I tend to think that that would be a permissible restriction, right? Because even if unusual and dangerous weapons are within the scope of the Second Amendment, so they get some kind of heightened scrutiny, right? From what the courts have said, right, that means intermediate scrutiny. So we'd ask, does the government have an important interest? Preserving public safety is an important interest. Is there a substantial relationship between that interest and the limitation, right? At least there need to be a record made, but you have instances like the shooting in Tucson where the gunman is stopped when he has to reload, and that should be enough for a court to say, well, there's a reason to limit the magazine capacity. That is that if you get in a mass shooting situation, the shooter has to stop and people around can stop the shooter. That then would satisfy scrutiny. Now, it's possible that it wouldn't, because courts have gone in 2 directions in applying intermediate appropriate scrutiny. One is the direction I read to you before from Judge Wilkinson. The other would be typified by Judge Posner on the Seventh Circuit, who goes through the record and sort of fly-specs all of the studies and says that with respect to the regulation in that case, which was essentially a prohibition on possession of firearms outside the home for self-defense. There he says, well, the record just doesn't do enough to prove to me that this will keep the public safer. Right. If you take the other view, which is more deferential to the legislative judgment, then I think the provision would be upheld. And so I think one of the really big issues still pending before the court, still to be resolved, is how much deference should there be to the legislative judgment that a particular measure, like limiting magazine capacities, will in fact promote public safety. If judges are like Judge Wilkinson and say, we're going to defer to the legislative judgment, right, will be judicially restrained, then those laws will be upheld. If, on the other hand, the judges are more activist in the mold of Judge Posner, they'll go through the record and say, well, we know better than the legislature did. The legislature's judgment is insufficiently supported, and so it's struck down. Right? I don't know. Nobody has a crystal ball to know which way the courts are going to go on that.
Or if they go like Brown versus Board of Education, they'll cite studies that say black children didn't like to play with white dolls and vice versa, so we'll get into all that kind of research. By the way, a concealed carry holder rushed to the scene after the Gabby Gifford shooting, and the shooting had stopped, and he didn't have to draw his weapon, but helped restrain the shooter. So had there been a reload, who knows?
I'd love to hear both of your perspective on not the focal case of gun bans, but how about background checks and then regulating secondary markets, gun shows?
Sure.
Do those issues, in your opinion, impinge upon constitutional concerns?
I go first. Generally not. Let me address the so-called gun show loophole. I've got a gun in my car. I meet you and you show me your concealed carry permit that you got yesterday. That means to me that you have a clean record. And I say, you know, I need a little money to get back to Mobile. Would you give me $200 for this? That's the gun show loophole. And I give you a bill of sale and you buy the gun. People do that at gun shows who are not federal firearms licensees. That's the whole gun show loophole. Most people who sell guns at gun shows are federal firearms licensees, and the exact same background check you have to go through that you go through at a store, you go through there. Now, there are plenty of holes in that. One of the major holes being with the mental health system. And, of course, some of our good liberal friends had, and there were abuses. You had 2 doctors could commit you to a mental hospital back in the 60s with nothing more than that. But we've gone to the exact extreme now. And I see it constantly. The jails are full of people with mental problems, and they're not even getting their medicine. I'll order somebody to have their medicine and just want to get their medicine. But I don't have a problem with that in general as long as it doesn't become a national database. And I think it's perfectly reasonable and constitutional to do the background checks. I just think, unfortunately, the government isn't very efficient. And you see it all the time with private records getting out. Follow up.
You're highlighting the question there. With the national database, at what point is there a Second Amendment challenge? I mean,
well, there you go.
You would tolerate some legislation.
Yeah, let's kind of go into one. Many drugs are sold off-label for other purposes. A lot of people take antidepressants for sleep problems. Let's say that then an edict comes down, nobody taking antidepressants can be approved to own a firearm because by nature they're depressed, and we have studies that show they may go kill people. Well, some 60-year-old man that's taking an antidepressant for his sleep that is not depressed, he's deprived of his Second Amendment rights. I think that's where you have a problem.
Yeah, and one of the other categories that the court said is presumptively valid would be limitations on who can possess firearms, felons and the mentally ill in particular. right? And a background check is just a way of enforcing those presumptively valid limitations so that it's hard to see how a background check would raise a serious constitutional problem. I suppose where you get to it is that while people use the term gun show loophole, in fact, it's much broader than gun shows, right? In fact, it's not even principally gun shows. It's
Private sales.
private sales, right. Anything that's not a sale by a federally licensed firearms dealer is outside of the background check system. And so the question is, can background checks be applied to those? Now, as to a sale, I think the answer is clearly yes. A sale is economic activity, and even if the activity is purely local, as long as it's economic activity, we all know from the Lopez case, that's something that Congress can reach if in the aggregate it has a substantial effect on interstate commerce. All economic activity in the aggregate has a substantial effect on interstate commerce. So Congress can regulate those purchases and sales.
Except the decision not to purchase health insurance policy.
Right, which is apparently not economic activity because it's economic inactivity, and that prefixes all the rage. But what about a transfer that's not commercial transfer? So I give a gun to my daughter, right? If I give my daughter a car, if I've given it to her title, there's something that has to be registered. Okay, if I just let her use my car, that's different. But if I'm actually giving her ownership of the car, if I give her a gun, right, is that an economic activity? Okay, perhaps not. Okay.
How about if you own it joint and severally and you die of operation of a law, then she would get your gun?
She would get my gun. And the question would be, is that something that is economic activity that the federal government can reach, right? And you can see the argument that it's not economic activity. She just got the gun as a gift or as a bequest, right? But there's another sort of subcategory under Lopez, which is if the federal government adopts a comprehensive economic regulatory regime, like the prohibition on the sale of marijuana. It can include in that prohibition any transfer of marijuana, even if it's not a commercial transfer. So if I have a marijuana plant in my backyard and I give the marijuana to my neighbor who suffers from glaucoma, right, that can be brought within the federal regulatory regime because that's a necessary and proper exercise of federal power, because if that can be held outside of the federal economic regulations, the federal economic regulations become ineffective. Now, if the same argument could be made that the prohibition on sales of guns to people who are mentally ill or who are felons requires us to include within that non-commercial transfers of firearms to those persons, then under the necessary and proper clause you would say that the federal government has the authority to sweep those transactions in as well. Okay, now all of this should indicate to you I don't know the right answer to that question. It's a tough one, it's on the line. So in as much as your question is where does the Second Amendment come in, I think that's where it comes in. And if I'm counsel for the NRA and I'm looking for a case to challenge, I'm not going to bring the local sale. I'm going to wait for the local gift, and I'm going to bring that case. Now, I still think there's plenty of case law out there that would allow a court and would allow the Supreme Court to say this is just like the marijuana case, and a federal law applying the background check requirement to that transfer is also permissible. But it seems to me there are some differences, and it's a tough case.
You'll be surprised to hear this from a judge. I think we need to relook at the felons not owning guns. There are almost 10,000 federal felonies now, including bringing lobsters into the country in plastic boxes instead of cardboard boxes. And we have various types of basically bad check cases in Alabama where you're a felon. And I'm not really so sure that somebody that's written a bad check when he's 22 ought to lose the right for his life to defend his family. It's something that
or to vote.
Yeah, it's easier to get your right to vote back. Right. But I think that's something that ought to be looked at. We probably all commit a felony in this room.
Yes, sir. I just know there's a bill currently introduced in Alabama House taking the concealed license out of
I'm glad you're asking that. That's kind of my issue. Alabama, you're talking about shall issue?
Yes.
Alabama is one of about 6 states that still has a may issue license. And the other states are California, New Jersey, blah, blah, blah. And every sheriff in this state has it. I'll tell you the typical one. I have a friend who has a client who was, how many people have a, especially when you get over 50, a Monday, Tuesday, Wednesday, Thursday, Friday, pill container. That's illegal, by the way, to put controlled substances, take them out of their container that the drugstore issued them in. Young man was arrested. He didn't have his in his container. Charges were dropped later. He can't get a permit from the Mobile County Sheriff because he's been charged with that. I'll give you a quote from a sheriff in Alabama. The reason we have a lot of these laws is to keep the ends from getting guns. That's the kind of abuses that it brings up. If you meet the criteria, you ought to get your permit. And it shouldn't be subject to the sheriff of so-and-so county saying, well, you got to have a full-time job, or this sheriff saying, as long as you don't have too many speeding tickets, or this other sheriff saying, if you're married, it ought to be, if you meet the requirements the legislature has set out, it shouldn't be up to some sheriff to decide he's going to impose additional restrictions.
Yeah, although I should say that's a problem of prosecutorial discretion quite generally, and I think people are familiar with the abuse of prosecutorial discretion in many, many realms other than just with respect to gun possession. Although, one word in favor of prosecutorial discretion, on the way driving here this morning, I was pulled over by one of Alabama's finest for slightly exceeding the speed limit.
We told him to do that.
Yeah. But in an exercise of his discretion, he let me go with a warning.
I get pulled over more than anybody. Most of the time they have a gun coming at me because they'll see the black rifles in the back.
Judge, I'm
Yeah.
curious what your criteria is for using the weapons against the federal government.
That's something that you'll never know until it happens. And I know that isn't the answer to your question, but I would go back to Judge Kaczynski's quote, where nobody will enforce court decrees, where the elected officials canceled the elections, that type of thing. But I think it's one of those things, often quoted about, Potter Stewart and pornography. You're not going to know it until you see it.
Right, let me just say, with respect to that, right, the Second Amendment begins by saying a well-regulated militia being necessary to the security of a free state, the right to keep and bear arms shall not be infringed. So it talks about militia. One of the odd things about Heller is, in the Heller opinion, the Supreme Court says the core purpose of the Second Amendment is the right of self-defense in the home. Now, you would think that since the Second Amendment is the only amendment that actually says what its purpose is, that the core right of the Second Amendment would be participation in a militia, right? Not the right of self-defense in a home. That might be in there too, but you would think the core is militia, right? It's pretty clear from Heller that the court might not even regard possession of firearms in connection with militia service as being protected by the Second Amendment. And the reason I say that is when you look at the list of presumptively valid regulations, the one we were talking about before is unusual and dangerous weapons. What does that mean? Well, grenade launchers, flamethrowers, surface-to-air missiles, the things you would need if you really wanted to repel federal tyranny, right? I mean, if you want to go Red Dawn, and you and your friends be able to stop an army, you're not going to do it with even an AR-15. That isn't going to be satisfactory. If that's what the Second Amendment is about, then Heller you ought to regard Heller as a really disappointing case, because it doesn't in any way vindicate that view of the Second Amendment's purpose. And in fact, it by implication negates that view of the Second Amendment's purpose. Right? And so, and honestly, I think the idea that I'm going to possess an arsenal of weapons that's going to create a deterrent against the federal government acting oppressively against me is just, it's fantasy, right? That's not what will deter them. Right? What will deter them is our participation in the democratic process. That's our protection. The right that is protective of all other rights is not the right to possess and bear arms, it's the right to vote.
Let me mention, though, and I understand the professor's reasoning, I think the United States would still be in South Vietnam if that thinking held true. We had a bunch of SKSs that were 50 years old run us out of the country. It was the determination to win that ran us out of South Vietnam, or won their war, whatever you call it. And that's what generally wins. There are thousands of cases of unarmed or underarmed people that have fought asymmetrical wars against much larger, much well-trained, and better armed forces, and have won.
We also left Vietnam because of our own democratic process, right? Not guns here at home, but rather people taking to the street, exercising their rights under the First Amendment, and
of course, because we were losing
the vote. Right, well sure, that's what got the public thinking the way they were thinking, right? What galvanized public attention, but that's what pulled us out of Vietnam.
One more question?
Yeah, just quickly. Wouldn't you say that the current view of the Second Amendment by the Supreme Court would be much a more accurate view than the very strict view? If we took a very strict view, we would say, well, at the time of the ratification of the Second Amendment, women didn't serve in the militia. Therefore, women have no right whatsoever to bear arms.
One thing I want to mention, the Supreme Court's composed of 9 individuals. If anybody doesn't think politics takes place in the Supreme Court and every appellate court, they're incredibly naive. There are coalitions that are built. Would you give me this? I'll give you that. That's how those decisions are formed. So just because we have the state of the law right now doesn't mean it's going to be the state after the next appointee or after the next appointee. And I guarantee you that's what went on with Heller.
Right. The other thing is, and I don't mean to get into a debate about an originalist versus an evolving constitution at all, but so even if you take an originalist view of the Constitution, you still have to take account of constitutionally and legally binding developments since the Constitution's ratification. One is the amendment that is the Second Amendment, but another would be the 14th Amendment. And that's why women would have the right to possess arms along with men, whatever possessory rights the Second Amendment confers, right? The other thing, though, is I don't think we have any idea what the Second Amendment meant when it was adopted, right? It's a train wreck of the English language. It starts with this clause about the militia. It ends with this right of the people to keep and bear arms. What connection do the two clauses have to one another? Well, we can go back and pick the sort of founding era quotes that we like and present them in a way that's favorable to the conclusion we want to come to, right? Justice Jackson talks about that in his Steele seizure opinion. But I don't think historically there is any real good understanding of the Second Amendment. I mean, we can go back, we can debate Blackstone and the clause about the arms that are legal, right? Now, that might have referred to the arms that people were legally required to possess, but Blackstone also knew that the English Bill of Rights protection was limited, right? Catholics were not allowed to keep and bear arms. They were specifically excluded from the right to bear arms. I'm Catholic.
1%
right?
of the population of England, though.
Well, if you, if you don't count Ireland.
Well, I don't think it was.
where my
We're talking
ancestors come
England,
from,
not UK. Yeah.
Which well, this was part of the court's debate in Boumediene over where habeas corpus extends and what was the status of Ireland. Certainly, the English kings thought of themselves as the kings and queens of Great Britain and Ireland. That's how their troubadours introduced them. So, you know, we can go back and look at that history, and you can say, that's a reference to the legal requirement that you bear arms. Okay, maybe. Or I can say, that's a reference to the fact that the law prohibits people from bearing arms, and consistently with the British tradition that rights existed to the extent that Parliament decided not to infringe them, right? And that's what Blackstone means to refer to. And who's right? Well, I think, of course I am, but I think for the most part, history doesn't give us a good answer. So I'm not sure that that kind of originalist way of looking at the Second Amendment actually gets us anywhere.
Let me just mention, though, we've got 13 conventions that ratified the Second Amendment. Look at the debate that took place at the individual conventions. And it's real interesting. But I think the originalist position will prevail.
Okay, I think it would prevail if there were one, but I don't know that there is one, right? There are 13 state conventions that debated all of the Bill of Rights, and the Takings Clause, no one seemed to even realize that went into the Constitution, right? But there it is, and so, you know, what do we do with that? I just think that's a pretty tricky way of going about interpreting the Constitution. Yep.
When we think about the gun control debate, I feel like the big failing within the debate within our society is that we don't look at the root of the violence at all, and kind of our understanding of human nature is that being a part of the failure of that. When we look at England, you know, they've outlawed guns. You know, the police have guns, but none of the citizens do, and they've seen a rise in gang violence using knives. And you know, you have to be of a certain age to even get a buttermilk, to get a butter knife. And so I feel like, you know, we kind of continue to have a rise in the amount of regulations on guns in America, but we continue to see more violence. Isn't this a failing of us to recognize the background of human nature and the failure that we don't need any more regulations?
We like quick fixes. I mean, this is going to seem strange from a so-called conservative.
Did everybody hear the question?
One thing. A lot of poor people steal because they're poor. I mean, that's that simple. You know, I mean, you're right.
Well, I guess I'm sure you're right that we should look at root causes, right? And we should try to figure those out. But if there are also regulations that can make us safer, that make lethal events less lethal than they otherwise would be, why shouldn't we adopt them? Right, and we ought to take sort of a fact-based view of that, right? Instead of coming from some sort of dogmatic paradigm that says the answer to bad guns is more guns, right? Sort of taking from the First Amendment, the remedy for bad speech is more speech, right? The only way to stop a bad guy with a gun is a good guy with a gun, right? Well, maybe, but maybe not. I took that from my right? Maybe that's right, maybe that's not right, which should lead everyone to agree that we shouldn't have limits on the information that's available, that's collected, and studies that are done. And unfortunately, right now, there are laws buried in our appropriations bills that prevent that kind of information from being collected, that prevent the federal government from funding studies that would help us to know what kinds of regulations might actually be effective and which ones might be ineffective. Right, for people who care, not coming from a dogmatic perspective, but for people who'd really like to know what seems to work, what doesn't seem to work. The information is hard or impossible to come by.
There is a class that starts here in about 10 minutes. So
We don't mind if they come in.
Oh. I would love for them to come in. But I wanted to make sure we had an opportunity to thank our speakers, because I know some of y'all have class as well. And thanks to all for coming. I wanted to make a quick plug for ACS National Convention in June. Sign up for that. And then also ACS elections are next Tuesday in the room below, 114.